The ranch had always been quiet in a way that felt earned. Wide stretches of land, uneven earth shaped by years of work, and fences that marked ownership not just by posts and wire, but by history. This wasn't a manicured suburb with identical lawns and matching mailboxes. This was open property, legally purchased, properly zoned, and intentionally distant from the reach of neighborhood control. Or at least, that was how it was supposed to be. The morning started like any other. Dust hung low over the dirt road, the sun was barely high enough to cast long shadows across the pasture, and nothing hinted that the day would spiral into one of the most aggressive overreaches imaginable. There were no letters taped to gates, no warning notices slipped into a mailbox, no phone calls demanding compliance. There was only the sound. At first, it was distant. A low mechanical hum that didn't belong in a place like this. Ranch land had its own soundtrack: wind, animals, the creak of wood, the occasional engine passing far away. This sound was different. Heavy. Industrial. Getting closer. By the time the shape appeared on the horizon, it was impossible to mistake. A massive crane, towering above everything around it, crawling forward with deliberate intent. Behind it came trucks, equipment, and workers moving with the confidence of people who believed they had every right to be there. The kind of confidence that only comes from paperwork signed somewhere else. This wasn't construction next door. This wasn't utility maintenance on public land. This was happening directly on private property. The land they were entering wasn't under the HOA's control. It wasn't part of their development. It wasn't subject to their rules, bylaws, or aesthetic guidelines. The ranch predated the HOA entirely. It existed before the gated entrances, before the monthly fees, before the obsession with conformity. Yet here they were, rolling in heavy machinery as if ownership meant nothing. The assumption was clear. They believed rural landowners didn't understand zoning law. They believed distance equaled ignorance. They believed that if they moved fast enough, no one would stop them. The purpose of the invasion became clear quickly. Stakes were placed. Ground markings appeared. Equipment was positioned with precision. This wasn't exploratory. This was planned. Sewer pipes were being laid, not around the property, but straight through it. The HOA had made a decision. Instead of negotiating easements, instead of purchasing rights, instead of even notifying the landowner, they chose force masked as bureaucracy. They relied on the idea that legal complexity scares people. That paperwork overwhelms. That by the time someone realizes what's happening, the damage is already done. They underestimated the situation entirely. This ranch wasn't just land. It was protected by a web of legal boundaries reinforced by county records, state statutes, and federal property law. The area they were attempting to excavate wasn't eligible for implied easements. No emergency clause applied. No utility exception covered what they were doing. And most importantly, the HOA had zero jurisdiction beyond their mapped development. Still, the machines moved. The crane's arm swung slowly, methodically, casting a long shadow across the ground as if claiming it. Dirt was displaced. The first cuts into the soil began. Each movement deepened the violation. What made the moment especially surreal was how routine the workers treated it. Clipboards were checked. Measurements confirmed. Everything suggested approval. Somewhere, someone had told them this was allowed. And that someone was wrong. The HOA's strategy relied on silence. If no one protested, if no one filed an immediate complaint, the work could continue long enough to create leverage. Once pipes were in the ground, removal would be expensive. Once infrastructure existed, negotiations would favor the party that had already acted. It was a calculated gamble. But they failed to account for preparation. This wasn't a landowner unfamiliar with legal language or intimidated by official-looking vehicles. Years earlier, when the HOA development first appeared nearby, research had been done. Deeds were reviewed. Boundary surveys were filed. County zoning maps were studied line by line. The possibility of conflict had been anticipated long before the first crane ever rolled in. That preparation now mattered. Every foot of land being disturbed was documented. Every machine entering the property was logged. Every action taken without consent was stacking evidence. The law doesn't move fast, but when it moves decisively, especially when violations are blatant. The HOA thought this was a simple expansion project. A shortcut. A quiet grab of land that no one would challenge. They thought they were dealing with someone isolated and uninformed. What they were actually doing was building a case against themselves in real time. As the sun climbed higher, the scale of the operation became undeniable. This wasn't a small trench. This was a permanent alteration. A statement of power. A belief that authority could be assumed rather than earned. But power doesn't come from cranes and contracts alone. It comes from legitimacy. And legitimacy was something the HOA didn't have. By the end of the morning, the ranch no longer felt quiet. Not because of noise, but because something fundamental had shifted. Lines had been crossed. Boundaries ignored. And a confrontation, legal, methodical, and unavoidable, was now inevitable. The HOA had made their move. They had no idea what response was coming next. The HOA believed momentum was on their side. By the second day, the operation expanded as if permanence alone could justify legality. More equipment arrived. More soil was displaced. The trench grew longer, deeper, more invasive. To an outsider, it looked official enough to discourage interference. That illusion was intentional. Heavy machinery has a psychological effect. It implies authority. It suggests permits have already been approved, that resistance is pointless, and that the only option left is acceptance. The HOA counted on that assumption. They always did. What they didn't see was the quiet counteroffensive already in motion. While the crane's arm continued carving through the land, documentation was being assembled with equal precision. Property deeds dating back decades were pulled. Survey maps showing unmistakable boundary lines were reviewed. County zoning ordinances were cross-referenced with state statutes governing utility access. Every clause the HOA hoped would protect them did the opposite. There was no recorded easement. No emergency declaration. No public utility mandate. The sewer project served a private development, not the public interest. That distinction mattered more than the HOA realized. HOAs often blur the line between authority and convenience. They rely on residents assuming rules are laws and fines are enforceable judgments. But outside their mapped territory, those assumptions collapse. The ranch existed beyond the HOA's jurisdiction, beyond its covenants, and beyond its reach. Still, the HOA pressed forward. Their confidence wasn't accidental. Somewhere, an internal decision had been made that the risk was acceptable. Perhaps they believed the landowner would eventually accept compensation. Perhaps they assumed legal action would take too long. Or perhaps they thought rural property owners wouldn't know how to respond. That was their biggest mistake. Every move the HOA made without permission strengthened the legal position against them. Trespass wasn't theoretical anymore. It was visible. Documented. Ongoing. Each foot of pipe laid without consent multiplied potential damages. Each machine operating on private land without authorization exposed the HOA to escalating liability. And then there was environmental impact. Excavation disturbed protected soil zones. Drainage patterns were altered. Livestock access was compromised. These weren't abstract concerns. They were measurable violations with regulatory consequences. Agencies cared about those details. Courts took them seriously. The HOA had assumed this was a dispute between neighbors. It wasn't. It was a property rights violation with regulatory implications, and the law doesn't favor organizations that ignore boundaries just because crossing them is convenient. By midday, formal notices were prepared. Not emotional complaints. Not angry objections. Structured, legally precise documents outlining unauthorized access, active trespass, and immediate demand for cessation. They cited specific statutes. They referenced parcel numbers. They left no room for misinterpretation. The timing was deliberate. Stopping construction mid-operation is disruptive. It creates cost. It creates questions. It forces accountability. The longer the HOA continued, the worse it would look when the record showed they were warned and ignored it. And the record was already forming. The HOA, meanwhile, continued acting as if resistance would fold. Workers followed instructions. Machines moved forward. No one stopped to question whether they should still be there. That was another flaw in the plan. Contractors rely on the legitimacy of whoever hired them. Once that legitimacy collapses, they scatter quickly. All it takes is one doubt. The moment that doubt entered the equation, the entire operation became unstable. Contractors don't want to be named in lawsuits. They don't want to be liable for trespass. They don't want to explain why they kept digging after formal notice was delivered. The HOA thought silence meant compliance. They didn't realize silence meant preparation. As the afternoon wore on, the difference between perceived power and actual authority became clearer. The crane still stood tall, but its presence no longer felt dominant. It felt exposed. Every swing of its arm was another action that would need explaining later. The HOA had crossed a threshold. They could no longer pretend ignorance. They could no longer claim misunderstanding. The evidence showed intent. And intent matters. What they also failed to consider was precedent. Allowing an HOA to seize land through construction would invite scrutiny far beyond this project. Counties don't like that. States don't like that. Courts certainly don't like that. The implications reached far past a single sewer line. By late afternoon, the operation slowed. Not officially. Not announced. But subtly. Checks took longer. Measurements were re-verified. Phone calls were made. Someone, somewhere, was starting to realize this wasn't going according to plan. The crane remained, but its authority was fading. The HOA had believed this was a matter of control. A show of dominance. A reminder that development power outweighed individual ownership. What they were learning instead was that ownership backed by law doesn't bend easily. The ranch wasn't fighting with noise or confrontation. It was fighting with facts. And facts don't negotiate. As the sun dipped lower, the construction site looked less like a victory and more like a liability waiting to explode. The trench stood open. The equipment idled. The future of the project hung in uncertainty. The HOA still had a choice. They could stop now and minimize the damage. Or they could double down and turn a violation into a full-scale legal disaster. They hadn't decided yet. But the clock was no longer on their side. By the third day, the illusion of control had fully collapsed. What remained was not a confident construction project, but a fragile operation held together by denial. The crane still stood on the ranch, but now it felt out of place, like evidence left behind at a crime scene rather than a symbol of authority. The HOA's biggest problem was no longer the land. It was the paper trail. Every hour the machinery had operated without consent had been logged. Every trench cut, every marker placed, every vehicle crossing the property boundary was documented with timestamps and coordinates. What the HOA assumed would be a quiet, unnoticed shortcut had transformed into a textbook example of unlawful overreach. And now, the law was paying attention. Regulatory agencies don't respond to emotion. They respond to violations. Unauthorized excavation, environmental disruption, and private infrastructure installation without easements triggered multiple layers of oversight. Once those mechanisms activated, the HOA lost the ability to control the narrative. The ranch wasn't just private property anymore. It was a protected legal position. The HOA attempted to reframe the situation. Internally, they treated it as a misunderstanding, an administrative oversight, something that could be smoothed over with compensation or revised paperwork. But those options evaporated the moment intent became undeniable. Continuing work after formal notice removed any claim of good faith. That distinction mattered more than they realized. Good faith mistakes get corrected. Willful violations get punished. The contractors were the first to feel the shift. Suddenly, permits were questioned. Authorization documents were scrutinized. The absence of a recorded easement became impossible to ignore. Liability loomed, and contractors don't absorb risk for someone else's arrogance. One by one, engines shut down. Activity stalled. What had once been a coordinated operation turned hesitant and fractured. The crane stopped moving. Without the machinery, the HOA had nothing left but arguments, and arguments don't carry weight without legal standing. Their authority ended at the edge of their development, and that boundary had been crossed so clearly it couldn't be redefined. The consequences escalated quickly. Restoration requirements were triggered. The land would need to be returned to its original condition at the HOA's expense. Soil testing would be required. Drainage impacts would need correction. The cost wasn't just financial, it was reputational. HOAs rely on the perception of competence. This incident exposed recklessness instead. The ranch, by contrast, emerged stronger. What could have been a loss became a confirmation. Property rights weren't theoretical concepts printed on deeds. They were enforceable protections backed by law. The attempt to bypass them failed not because of force, but because of preparation. The HOA faced internal fallout. Board decisions came under scrutiny. Approval processes were questioned. Liability concerns surfaced. The same organization that once believed it could dictate outcomes now had to answer for its actions. And the answer wasn't flattering. The final outcome was unavoidable. The sewer project was rerouted. Not negotiated. Not compromised. Rerouted entirely off the ranch. The land was restored. The equipment removed. The invasion reversed. The crane left the way it came, slowly, quietly, stripped of its assumed power. What remained was a lesson the HOA would not forget. Development does not override ownership. Convenience does not replace consent. And authority does not exist just because someone claims it does. The ranch returned to its natural rhythm. The dust settled. The land healed. But something else had changed permanently. The HOA, once emboldened by unchecked control, now understood limits existed, and that crossing them had consequences. They expected ignorance. They encountered the law. And the law drew a line they couldn't cross.